Good morning, and thank you all for tuning in to what we all hope is going to be a really insightful session. My name is Tom Scorfield. I'm the Global Co-Head of CMS's Intellectual Property Group, and I'm joined here today by many of my colleagues from a number of practice groups across CMS worldwide. I also know we have a global audience of guests here today, so welcome to all attendees wherever you might be. Thanks to all of you for taking the time out of your no doubt busy schedules to explore a topic that's becoming a crucial commercial issue for corporates across almost every sector and every jurisdiction. We're really delighted to have you all with us today. So the issue on our agenda to talk about, it's not a secret, it's trade secrets, and it's a topic we've been exploring in depth as part of a multidisciplinary global team across our employment, commercial, and intellectual property groups. Now, speaking personally, working in IP, I've spent my whole career looking after intangible assets of my clients. Some of those assets can be protected by patents, by trademarks and copyright, but others can only really be protected by, well, keeping them secret. And these secrets support your business, they drive innovation and growth. It might be proprietary manufacturing processes, test data, AI, algorithms. Whatever they are, we know that trade secrets are a very fast-growing component of corporate value. And in this report, we're asking, in a digital online age, how can successful companies like yours maintain and exploit that value, but still keep your trade secrets safe and secure? What are the threats to safeguarding trade secrets? Are they growing? How concerned are you? What actions are your management teams taking? And to help us answer those questions and pose some more, we commissioned exclusive research from the Economist Intelligence Unit, surveying over 300 senior executive personnel in Europe, the US, and Asia in depth on the issue of trade secret security. I'm sure some of you tuning in today will have participated in that research, and thanks again for taking the time to do so. To present our research today, we'll shortly be joined by Ailia Haider, who's a research analyst at The Economist. Ailia, welcome. And the findings of this research are quite compelling, but as well as presenting the insight itself, we really want to explore today how you and we can take that insight to help make your business more resilient and secure for the long term. We'll look at things like what needs to happen operationally, legally, and just as important, culturally, to properly safeguard trade secrets. And to that end, I'm really pleased to welcome my fellow CMS partners, Ailia Haider, Anna Netherton, and Joel Vertes, who will comprise our panel a little later to explore the commercial implications of the research, as well as to answer any questions. Now, if you do have questions during any of the sessions, please put them in the chat box. We'll do our best to answer them today or as a follow-up after the event. And I'll also give details how to get the full research at the end of today's session. So now I'd like to hand over the virtual floor to Ailia Haider of The Economist to present our research, Open Secrets, Guarding Value in the Intangible Economy.
Hello, and thank you for joining this presentation today, Open Secrets, Guarding Value in an Intangible Economy. I hope you're keeping well and safe wherever you're based. My name is Ailia Haider, and I work for the Economist Intelligence Unit. And I'm also the research and project lead for our latest thought leadership research program on trade secrets, commissioned by CMS, which I'll be walking you through today. So the aim today is to give you all a look into the key findings of our new research by highlighting three key things: the growing threat and vulnerability of intangible assets, the primary perceived threats of these assets, and how companies can and should be working to safeguard them. So let me begin by introducing the research program. Our research is driven by the rise of intangible assets. There has been a crucial shift in where companies derive their value from over the past 50 years. Companies used to derive value from the physical capital that they owned, including the buildings that they owned or the products that they produced. But in today's technologically advanced world, companies' value is mostly built on intangible capital, including algorithms, software, engineering specs, and customer data, to name a few. And this is clear when looking at S&P 500 companies, as is shown on the slide, who have seen a dramatic shift since the 1970s, when their intangible assets made up only about 20% of their value. Today, this has now reached 90%. And as companies embrace the online realm to conduct more and more business, the vulnerability of these intangible assets will only increase. So to explore this problem, CMS commissioned the EIU to develop a survey-based program, which looks at the value of trade secrets to firms, the prime threats to trade secrets, and how companies are protecting them accordingly. We surveyed over 300 corporate executives across 6 key sectors from 6 countries to reflect different regional nuances, including China, France, Germany, Singapore, the US, and the UK. We supplemented our survey program with expert interviews with academics and corporate executives to provide further insights into the most pressing trade secret trends. The survey insights have been packaged into a comprehensive report and a visual infographic, both of which will be available on the EIU Perspectives website and CMS's website as well. So exactly how important is the issue of trade secrets to corporate executives? Well, traditionally, the issue of trade secrets and their protection has been the focus of legal departments. And while this continues to be the case, and rightly so, it's not just legal departments that care about this anymore. Trade secret protection is expanding as a priority beyond the legal department into the boardroom, with over 70% of surveyed executives believing that this is a priority at the board level and the C-suite level of their organizations. But what is driving this heightened prioritization? Well, there are 2 key driving forces at play here. The first is the technological advancement and digitalization that is diffused into almost every aspect of our lives, including the way we work. For example, with the rise of and the increased reliance on cloud computing. Closely linked to this is the way in which companies are more and more embracing flexible working. Both of these trends have been exacerbated further by the COVID-19 pandemic. And as a result of these 2 trends, the majority of executives believe in 3 key things, which are really showing the importance of trade secrets to these executives. So firstly, it's that proprietary information is essential to their company's value. Secondly, that there is a need for increased financial investment, which is necessary to safeguard trade secrets. And thirdly, that a breach of these intangible assets could significantly impact their organization's finances. And with these 3 points, the value of trade secrets, the need for investment to safeguard them, and the financial risk of a potential breach, it's clear why trade secrets are top of the executive agenda. And because of the significant value these intangible assets hold for companies, there is a need to identify the key threats to trade secrets. Over the next few slides, I will dive into the most concerning threats that our survey respondents believe will increase the chance of trade secret theft or potential disclosure. And the first hurdle to cross is the lack of understanding about trade secret protection in the first place. 1/5 of executives face difficulties in defining what trade secrets are, while 1/3 of executives struggle with proving that theft or unlawful disclosure has happened at all. And both of these are very crucial when a company experiences trade secret misappropriation and seeks legal protection. As Anil Cheria, an executive from Cognizant, says, identifying your crown jewels is a worthwhile exercise, but it is an exercise in and of itself requiring sufficient effort. And without that sufficient effort put into clearly defining trade secrets and setting up ways to prove theft, companies who experience breaches will likely struggle in legal battles. And after the failure to understand the importance of trade secrets, the leading threat to them is a lack of robust cybersecurity. This external threat has been a long-standing issue, but it is on the rise because of the ongoing digitalization and increased remote working brought on by the pandemic. And juggling personal devices, virtual private networks, and multiple cloud-based systems means that companies are facing a growing number of threat vectors that could potentially compromise confidential information. And because of this, almost 50% of executives believe that this is the most significant threat to trade secrets, with executives in China, US, and France citing this as the top threat. And while the external threat of cyber attack is definitely notable, internal threats cannot be overlooked. Employee leaks and disclosure is a close second behind cybersecurity in the running for the top most significant threat. Almost half of executives are concerned by employee threats, mostly in the UK, Germany, and Singapore. And this type of threat can either be unintentional or intentional. Accidental leaks can be the result of overheard conversations, unsupervised devices, and accidental exposure to family members or housemates, which has been a growing concern as working from home becomes more and more common. Meanwhile, as companies have had to make the difficult decision of laying off or furloughing employees during the pandemic, they're likely to face the brunt of disgruntled ex-employees who may leverage their knowledge of confidential information to find employment with competing companies or to start up their own companies using that knowledge. And with these three threats, there is a need for companies to consider a diverse range of measures to minimize them. In trade secret legislation across the world, in order to be legally protected in the case of trade secret theft, companies must be able to prove that they have taken reasonable steps to protect them. So once companies have identified the threats to their crown jewels, they must turn their efforts to developing a toolkit to protect them. When developing this toolkit, there are a variety of measures that companies can leverage, ranging from internal-facing to external-facing measures. There are 5 key strategic tools that we have identified from our survey. Firstly, enhancing cybersecurity efforts, regulating employee activity, then bolstering contracts and business procedures to really boost confidentiality, restricting access to confidential information, and finally, and more broadly, integrating trade secrets into a wider company culture. And I'll walk you through each of these now. With cyber attacks being the top threat to trade secrets, it is fitting that executives believe installing cybersecurity software is the most effective countermeasure, with over 80% agreeing that cybersecurity is essential to successful protection of trade secrets in the long run. And this is reflected in the fact that this strategy has already been implemented, even more so than others, with almost 70% of executives' organizations having installed cybersecurity software to ward off threats already. However, it is important to note that a lack of cybersecurity expertise remains a critical hurdle, according to many surveyed executives. Interviewees validate this further and highlight that there is a need to work beyond the cybersecurity team's perspective, bringing in employees at all levels to really embrace cybersecurity best practices. And while cybersecurity is the perceived most effective tool to counteract any threats, there is an increasing focus on internal threats, as I mentioned. With increased flexible and remote working as a longer-term byproduct of the pandemic, companies are growing more and more wary of their own employees. In fact, over the next 2 years, companies are planning to implement more employee-focused countermeasures than any other type of countermeasure. 4 out of 5 of the measures on executives' forward-looking agenda target employee leaks, and this might include monitoring and surveillance of employees' activities, incentivizing staff to really protect trade secrets at all levels, and implementing robust offboarding measures such as certifying return of company information, strong exit interviews, and even disabling access to company information after an employee has left. But there are important regional and country-specific nuances between approaches to regulating employees. For example, while boosting the surveillance of employees is expected to be of highest priority on average across our sample of executives over the next 2 years, this is not as an attractive solution for European companies, primarily because it's a very restrictive data protection regime that they face, the GDPR, which can be quite complicated when juggling data protection and surveillance of employees. Next, after ramping up cybersecurity, the second most effective measure perceived by executives is the use of strong and robust contracts and business procedures to maintain a level of confidentiality. And while the use of non-disclosure agreements, work for hire, non-competition and non-solicitation obligations seems a fairly standard method for protecting trade secrets and any other confidential information, smaller companies are more likely to struggle with this. Professor Marks at Cornell University argues that this is primarily because, or in part because, early stage startups are more likely to suffer from a general lack of awareness and even a lack of power to enforce confidentiality. This was a particular hurdle in the dispute over the creation of popular social media site, Facebook. In this case, the founders of the social media site ConnectU, which was supposedly the initial concept that sparked the idea for Facebook, claimed that Mark Zuckerberg had stolen their idea to create a more successful Facebook. However, they were unsuccessful, or rather they were unable to successfully argue their case, in part because they hadn't taken enough protective measures or taken enough steps to ensure confidentiality. And moreover, they could not prove that the theft had happened in the first place. So it's quite a tricky case. And a crucial and rather more obvious element of safeguarding trade secrets and a strategy for safeguarding trade secrets is limiting access to them. Some solutions that, in practice can be used include limiting access to employees only on a need-to-know basis, ensuring password protection of digital files, even destroying confidential information once it's no longer necessary and it's a bit obsolete, but still has a confidential element to it, and also restricting physical access by placing important information in a locked safe, for example, as is the case with Coca-Cola's famously guarded secret recipe. While over 2/5 of executives believe routine access limitations are one of the most effective measures to protect trade secrets, only 55% are actually implementing this already, suggesting that this more obvious, mostly inexpensive, and highly effective strategy is being overlooked. And finally, linking all of these measures is the need for a corporate culture that encourages trade secret protection. To encourage employees at all levels to maintain confidentiality, honor contracts, and engage in cybersecurity best practices, organizations recognize the need to foster a culture that highlights the importance of trade secret protection. This may involve implementing a reward scheme for employees who identify new trade secrets or speak up about gaps in security. This may include fostering a healthy, safe space and environment for employees to speak up and listen up about potential misgoings on in the company. And also, it may include boosting employee satisfaction to minimize the risk of disgruntled employees. Almost 50% of executives' organizations have already incorporated trade secrets into their broader corporate strategy and corporate culture, and a third plan to do so over the next 2 years. But at the same time, over 1/5 of executives are rather uninterested in this strategy to protect trade secrets, which suggests that perhaps these executives may be looking at the short-term countermeasures rather than a longer outlook. So it's clear that there's a wide selection of protective measures that companies can and should be choosing from to protect their trade secrets. And it's also clear that the threat to these intangible assets is on the rise as companies navigate heightened digitalization and greater flexibility in working practices. And as a result, the call to action to protect these trade secrets is louder than ever. And underpinning this call to action are 3 key pillars that companies can focus on and should be focusing on as they embark on protecting their intangible assets. Firstly, there is a need to improve the general awareness of trade secrets. This is a very important initial step to understand company value. Without clearly defined trade secrets, legal battles will indeed be uphill battles. Secondly, there is a need to incorporate cybersecurity best practices. The key is investing in talent. This is quite a difficult feat, especially now when high quality cyber skills are very much high in demand. And finally, companies should be looking to develop and adopt a proactive and diverse trade secret strategy that incorporates measures including the ones highlighted earlier. This will benefit companies in 2 specific ways. Firstly, by minimizing the theft or disclosure of trade secrets from happening in the first place, which is excellent. And secondly, in the worst case scenario, this type of strategy will equip companies with enough proof of protective measures in the case of a legal court case or legal proceedings. Taking these initial steps at a time when the threat to trade secrets is growing is necessary to safeguard value in the ever-growing intangible economy, as only the most proactive companies will be the most protected companies. Thank you very much for joining me today. I hope that this was eye-opening, and I look forward to hearing any comments and questions that you may have. Please do feel free to reach out to me on my email address. As I mentioned earlier, the research and report is available on the EIU Perspectives website and the CMS website as well, if you want to look into the key findings in more detail. Thank you very much.
Hello, I'm Joel Vertes and the partner in the IP team here at CMS. Thank you again for joining us. I want to share with you some thoughts on the report and walk you through these today with some actions that we've identified as the most important things to do to protect your trade secrets. Now, the first thing to mention is that came out of this report is that the perception of the biggest threats that businesses face is slightly different to the reality. One of the outputs of the Economist report survey was to show us that respondents believe the top threat to the security of their trade secrets is cybersecurity. And similarly, which practices would be most effective in preventing the potential threats? Again, installing cybersecurity software came out. Now, of course, protecting against cybersecurity threats is a critical piece of any business's armory. CMS operates a 24-hour cyber hotline for clients, and regrettably, that's never been busier. So I certainly don't want to downplay the importance of it. But from a lawyer's perspective, as someone who's seen this on a day-to-day basis many times, cyber attacks happen, corporate espionage is a meaningful threat, but that's only half the story. Far more common are the innocuous leaks that happen on a day-to-day basis. That might be a drunk employee leaving a laptop on a train. It might be an employee moving to a competitor and taking with them some of your files or memorizing critical information. And even if you run the tightest ship yourself, leaks can also occur in the supply chain. For a business to have an effective trade secret strategy, it has to be a considered, holistic plan, and not one that's hastily pulled together in a crisis. It needs to address not only hacking and malware breaches, but also the mundane threats, which we know from experience could be minimized or almost eradicated altogether. So let's go back to the legal test. What is a trade secret? Well, we know it might be a manufacturing process, a way of doing business, or an algorithm, a recipe, or a chemical formula. It's the crown jewels of the business that you don't want to reveal. But the legal test under the Trade Secrets Directive that came in a couple of years ago says that it must satisfy these three criteria, being number one, it must actually be secret. So it can't be generally known or readily accessible. It has to be confidential. Number two, it has to have commercial value because it is secret. And number three, reasonable steps must have been taken to keep it secret. So in other words, these need to be demonstrable. You need to evidence what steps you have been taking. And we'll look at that in some depth today. But before we do, why would you choose trade secrets over other forms of IP like patents? Well, a patent is certainly a powerful right. In return for disclosing your invention to the world, you get a 20-year monopoly right. Someone can infringe your patent without even knowing you exist. But there are advantages of trade secrets over patents. So I have a client now, for example, who relies exclusively on trade secrets. They're nervous that by disclosing their innovation in a patent, an unscrupulous competitor with deeper pockets might simply start copying them, and either they'd never know or never find out, or never be able to prove it, or never be able to afford the litigation that might ensue. So let's get back to our three actions that will help minimize risks. These are, number one, identifying what the trade secrets are and categorizing them. Number two, protecting them. And number three, being ready for that crisis. So number one, identifying them. Someone has to take the proactive step of lifting the lid on the business and working out what are the trade secrets that we have. So look, there are degrees of confidentiality. On the one hand, on one end of the scale, there's know-how, things you will just learn from having 20 years experience in a business. Then there might be commercially sensitive information, financial information, for example. But what we're really talking about is those very core secrets that if the company owns, which, if known by a competitor, could destroy your competitive advantage. So how are you capturing those? Having a process to audit them and capture them is essential, more so if you're a business which knows that it's innovating constantly. You need to think also about, in relation to that second limb, why a secret has commercial value because it's secret. And that means applying some analysis to it. So for instance, how long and how much money would it take for a competitor to develop this information from scratch? Auditing and ranking these trade secrets is essential. Number two, protecting your trade secrets. So once you've categorized them, you need to take actual steps to protect them. And this isn't simply best practice. As I said, you need to be able to demonstrate what those steps are. So that means labeling them on the physical documents, segregating the electronic files on a different server or with password protections, and preventing people even from accessing bits of the building. Employees need to understand why they should act differently around those documents. My employment specialist, Hannah, is going to address this shortly in a little bit more depth, and she's going to discuss why there is a cultural shift that many businesses need to deploy, so that employees are proud to be in the loop on company secrets, and it becomes a point of pride to maintain that. Solid legal contracts are also critical here, and my commercial colleague Ailia Haider will also go into more detail on why contracts between employees and commercial partners are the foundations for a good trade secret strategy for any business. There are other litigation-focused options too, so like seeding your data or information with false information. So, for example, the mapmaker Ordnance Survey, they used to put a false bridge somewhere on a map, knowing that if that fake bridge appeared on one of their competitors' maps, they could prove straight away it had been copied. And many businesses are seeding data in that sense in order to help prove copying. Lastly, what to do if there's a leak, the enforcement steps. And this is all about crisis readiness. It's all very well doing great work and analysing what your assets are and then identifying which ones are the trade secrets. You've trained your employees, they know how to behave. Your IT team has good systems in place to prevent cyber attack. But when things go wrong, if you haven't thought about it, then you'll be left floundering. Once a trade secret is disclosed, sometimes that's pretty terminal. You've lost confidentiality and potentially your commercial advantage with it. Unless that is, you move quickly. First of all, being ready for that. You need to practice and prepare. And we at CMS can provide training and run war game sessions to test how businesses would react. There's a series of practical steps that business can take as well. The IT team might need to shut off servers. They might need to immediately preserve or recover documents or files. We might need to suspend employees. For this, you need your specialist team on site, a forensic investigator, a cyber response team, your HR team. All of these need to be briefed. And they need to be briefed on questions like, who do I call in IT? Are they contactable on weekends? Who on the board do I need to notify if there's a major leak? Honestly, sometimes I'm anxious for a client because they're reacting to a breach and they're asking us, well, what documents do I need? What are the legal costs going to be? How long is this going to take? Even running a mini tender process to try and appoint law firms. Now, of course, all of those are completely valid questions, and we can do what we can to work quickly. But those questions just impede the immediate and effective reaction that you need. Now, there are lots of steps that lawyers can help with as well, from being on side as a brief litigation team, to having pre-prepared cease and desist letters, to even having pre-written witness statements with blank spaces for the specifics. Getting the lawyers and the technical specialists on side in advance means you're not wasting time taking those steps in the middle of the greatest crisis your company has faced. So, to recap, a trade secret strategy needs 3 things. Number 1, identification of what the trade secrets are. Number 2, proactive ways of protecting them. And 3, planned strategies for what to do if there is a leak. The biggest mistake that we see clients making is just not being ready. You want to set yourself up practically and legally to be in the best position to enforce your rights. CMS has an international team of experts across IP, commercial, employment, disputes, all of whom work as a team in delivering advice to clients to help them prepare in advance and, of course, to assist them in the crisis mode. Thanks very much for your time, and I'm going to pass on to Hannah to discuss the employment piece.
Hello, I'm Hannah Netherton, a partner in the employment practice at CMS. I want to begin by talking about why people take trade secrets. Some of the things I hear in my world are, I didn't realise the information wasn't mine. We all have access to that data. Everyone does it in our industry and the company won't bother taking any action. Or, I'm entitled to this because they treated me so badly. Perhaps you've heard some of those too. However, whether all of those examples amount to trade secrets theft and so offer an organisation some kind of recourse or enforcement options isn't as clear as you might hope. For example, let's look at I didn't realise it wasn't mine, or we all have access to that data. In order to enforce a breach of trade secrets protection, a company must show it has taken reasonable steps to protect that trade secret by, for instance, making sure that it's kept secret, that access to it is limited, and by making clear that the data does not belong to the employee. So in some cases, infringement will be clear-cut, but in others, it will be more nuanced and often harder to prove. What this means for organisations is prevention is better than cure when it comes to protecting these types of intangible assets. Let's talk about the biggest threats when it comes to employee leaks. These often come when employees leave, typically combined with a move to a competitor. So what contractual protections can employers use to deter leavers from breaching confidentiality and then to take enforcement action if they do it anyway? This is going to depend on the jurisdiction you're operating in. In the UK, we can enforce trade secrets theft through the common law route, relying on equitable or contractual obligations. We now also have the Europe-wide Trade Secrets Directive, which creates a legislative framework for protection of trade secrets. Either way, the employment contract is key. Getting this right is essential and one of the reasonable steps organisations need to take to protect their trade secrets. They also need to create an environment in which those secrets are protected. This includes thinking not just about contracts, but also policies and processes and internal protection of data. When it comes to onboarding processes, for example, is it being made clear to employees that the company doesn't want another organisation's confidential information? We also need to look at offboarding processes, including simple things like the return of company laptops. You would be amazed at the number of cases I deal with where the laptop has not been returned, USB sticks are unaccounted for, and passwords to cloud accounts are unchanged. These are all important, but to understand why we need them, it's important to recognise the huge changes that have happened to how we work and the pressure this is putting on established relationships between companies and their employees. So I want to talk a bit about the two types of contract that exist between the employer and employee, specifically the social contract and the legal contract. Legal contracts offer businesses the necessary framework for the protection and enforcement of their rights, but the legal framework can't exist in a silo. When dealing with people, the social contract is equally as important and significant when it comes to managing intangible assets such as trade secrets. The pandemic has changed many of the historical workplace norms. Monitoring, oversight, surveillance of employees was always there in some form or another, even if it was a manager seeing who's in the office and how long an employee was there for. But management of remote working practices is a new horizon for many employers and a big looming threat. Remote working makes it much easier for bad actors to misappropriate trade secrets and confidential information without the same level of in-person monitoring. For example, if someone wants to leave an organisation, they may be going for interviews and their employer may get a sense of what's going on. The employer could then take steps to prevent data egress of some sort. When everyone's working from home, that behaviour is much more invisible. So employers need to build a security net around their social and actual contracts with their employees. Also, increased home working has seen us turn to more technological means of surveillance, and that makes people uncomfortable. It's a shift in that social contract. We're also seeing a changing regulatory environment with a greater focus on whistleblowing and a healthy speak-up culture. This, combined with, and this is something that the report touches on, a lower level of commitment from employers to their employees, creates a lack of reciprocity between individuals and the business that they're working for. And the social contract is there to prevent issues like theft of information from arising, and it involves trust between employers and employees and creating a culture of personal responsibility in which trade secrets are protected and managed. Having a policy and a training regime is, however, just part of the broader picture. Just as important is, how does a workplace value its people? How does it incentivize them? What is that level of mutual trust? What type of company is it? And this all strays outside of law to some extent, but do individuals feel they have a purpose? Psychologically, this is important for employees to feel they're invested in an organisation. But this social contract is not foolproof. There will always be bad actors as well as unintentional breaches. When a breach has happened, that's when the legal protections come into their own. In the UK, if we're taking an enforcement action, we need to be able to demonstrate what an organisation has done to protect its trade secrets. Exactly what constitutes reasonable steps is, in the UK at least, currently unclear because the courts haven't yet expressly dealt with this issue under the new trade secrets legislation. But we have a good idea of what they might be. For instance, appropriate contractual protections, appropriate policies, appropriate technical protections on documents like password encryption and limited access, and regular training for employees so they understand what's expected of them. So how do you stop people from taking trade secrets? Having a clear line of responsibility is important. Who is accountable for managing systems and compliance with those systems? Often these issues fall between the cracks. People think it's legal, or IT, or operations, or internal audit, or HR, or simply management's responsibility. Setting those expectations clearly will help empower people to manage those controls effectively. Also think about monitoring your programs. Once those systems are all set up, they mustn't gather dust. They should be reviewed to make sure they stay effective. Another important thing for organisations to do is contingency planning for what happens if there is a breach. Enforcement action typically needs to be taken extremely quickly to manage the fallout, but it can sometimes take too long to be able to work out what needs to be done and who needs to do it in the immediate aftermath of a crisis. Then, of course, there's litigation. That's our bread and butter, and we spend a lot of time guiding parties through the rough waters of injunctions and the court system, helping to achieve the best possible outcome. Looking ahead, there are potential changes to the UK legal regime in the pipeline, and not necessarily to the benefit of employers. So we're keeping a close eye on that. And this isn't an issue that's going away. It's here to stay and likely to be an ever greater risk for businesses as opportunities to misappropriate increase. CMS can help in identifying and defining trade secrets, putting in place the strongest contractual protections, auditing your policies and processes, advising on emergency planning, and of course, if it comes to it, helping you take or defend enforcement action. So lastly, don't just wait until there's a breach. Do all that you can to prevent it from happening in the first place. Thank you.
Hello, I'm Ailia Haider, a partner in the corporate and commercial law practice at CMS. There is a saying, prevention is better than cure. This report confirms what we see from clients. We see that trade secrets are not properly protected, and people are not aware that they need to implement measures to secure protection from both a practical side and from a contractual side. We need to raise awareness within organizations to implement the proper contractual arrangements around their trade secrets. What we see in the Netherlands is that with the Act based on the Trade Secret Directive, it is more and more important to have good contractual documentation. Because of this law, it is very important that companies have good non-disclosure agreements and confidentiality clauses in related agreements. What we also see is that most of the time there is not really alignment and a tailored approach in the documentation. People are aware that if they are going to start discussions with a new potential partner, that it is important to have an NDA. But they just grab an old one from the shelf, fill in new names, and that's it. We've seen very big companies that have no alignment between the NDA and related agreements. The documentation does not sufficiently describe what the trade secret is, whether and on what terms a party can use that trade secret, if parties are able to terminate an NDA and/or related agreements, what the consequences thereof are, or which law is applicable. Furthermore, it's not only about identifying what a trade secret is and how it was protected, contractually and practically, but also the analysis of what you have agreed upon in terms of, for example, the intended use is very important. My message to the C-suite or legal counsels is, it does not end with an NDA. An NDA is only one of the pieces of the puzzle, and to be able to show that reasonable measures have been taken, a company will need to ascertain that many other logistic, security and contractual measures have been taken. Think about the impact of Trade Secrets Directive and what is needed to be able to comply with this directive, not only contractually, but also with mundane, pragmatical activities that secure that information is kept confidential. On the infographic, there is a statistic that really stands out. 28% of respondents say that they lack awareness about trade secrets. This is a serious problem. Protection starts with identifying what is a trade secret, then ensuring good identifications and documentations to protect them. And then, of course, you need good cybersecurity, physical protection measures, confidentiality agreements with employees, etc., etc. Are you lost without an NDA? No, under Dutch law you are not lost, but it will be more difficult to prove that you had a trade secret and that it is unlawfully acquired and used. One of the key benefits of the Act is that it provides a helping hand from an evidentiary position, as the Act provides for examples of conduct which are deemed unlawful. Another aspect that procedure will, like arbitration, be confidential if a claim can be based on the new Act. So bringing a case on trade secrets is now possible without having to fear that your trade secrets are accessible to third parties during the proceedings. But this 28% figure, this failure to understand what constitutes a trade secret, this is serious. In the Netherlands, there is another aspect to consider. The size of your company is important. If your company is large and multinational, a court will expect that you have taken more far-reaching measures to ensure that information is not accessed too easily. Big corporates might therefore, more in general, have to be more critical in their assessment and evaluation of their internal and external guidelines, policies and measures around keeping information secret in order to rely on protection from the Trade Secrets Directive. As others have pointed out, cybersecurity is listed as the top threat. It is, of course, a huge threat, but other measures are equally important. Training your staff, having a clear policy in place, including a need-to-know policy with levels of access granted to certain people to certain information, and raising awareness of the importance and implications of trade secrets are important aspects for protection of trade secrets. It starts with the easy things. If I have a file containing trade secrets and an office cleaner can enter my room anytime and see the file or take notice of a trade secret, then it's not about cybersecurity. It's an access issue to an office or a factory or a plant. If we only focus on cybersecurity, then that misses the simple actions a company can do to meet the requirement of taking reasonable measures. So you may have a great state-of-the-art and updated IT system, but on the other hand, there is a leakage all over the place because basic security steps are not being taken on your premises. The report talks about intangible assets. However, a company could easily look at what's tangible. These can be seen. With cybersecurity, you will always have a risk. Hackers are all over the place and will always try. However, tangible assets, such as the file I mentioned earlier, could be kept in a locker. A company should not overlook the tangible assets it has. They are the easiest to protect. Why is protecting trade secrets important? A leak or breach could be a deal breaker in a transaction. If you don't take the protections the law requires, then it might be much more complicated in court proceedings. A trade secrets leak can destroy what a company is worth. In terms of doing business, if one company under an NDA discloses information to another company, and through a leak at the receiving company, the information gets out into the market, this would certainly harm the customer relationship if you didn't protect the trade secrets that were entrusted to you by your contractual partner. It is also important from a corporate law perspective, if the buyer is under an NDA, but there is a leakage of information by the buyer, the company they are acquiring could lose its value, a worst-case scenario for an M&A deal. So for me, it all starts with good documentation. I see a lack of alignment in those contracts, and no amount of training or IT systems will make that okay. The corporate and commercial law practice at CMS can help with drafting NDAs specific for businesses and industries and help to comply with the Trade Secrets Directive and the acts based on that directive. Our corporate and commercial law practice can offer a three-phased module. In phase 1, an audit will be done in which trade secrets and possible red flags are identified. In phase 2, contractual as well as non-contractual documents such as guidelines, protective measures, etc. will be drafted. Next to that, a protection strategy will be provided for the company. In phase 3, CMS will evaluate the implications of phase 1 and 2 in practice. To this end, training of key personnel can be provided and, if needed, a review and modifications could be enacted to ensure that trade secrets remain secret. Thank you.
Well, our time is almost up, although there's clearly plenty more to discuss. I hope you've all found this session valuable and it's provided you with a new perspective on the potential challenges, the risks, but also the opportunities in your business. Lots of points for follow-up from our panel or any of your usual CMS team. As mentioned, the full research report is now available to download on our website at cms.law, and we'll be emailing you a link to the report as well as some of the other materials supporting our expertise in the field of trade secrets more generally. Now, if you want to discuss any of the issues raised here today in more detail, or perhaps you'd like a tailored webinar or some training to present this research to your colleagues, please contact your CMS relationship manager or any of the speakers here today. And at CMS, we're really committed to helping you navigate this issue, both in the short and immediate term, but also with your long-term business strategy. So whatever support or additional insights you need, please don't hesitate to get in touch. And now I'd just like to wrap up by making some thanks. So thank you to Ailia Haider and the whole research team at the Economist Intelligence Unit who've supported us in this research. Thanks to Ailia Haider and Joel for being on our panel today, and also the CMS Business Development team who've steered and supported this project the whole way through, particularly Hans Scholten, Tanya Belcik, and Victoria Siegel. But most of all, thank you all for being here and giving up your time to reflect on this issue. We hope this is the start of an ongoing and rewarding dialogue on the issue of guarding trade secrets. But meantime, enjoy the rest of your day. We look forward to being in touch soon. Thank you.